Good afternoon, High 10 Partners, George Realty. We have a special speaker in the house, Attorney Louette Cowell, who is going to go over the eviction laws, some of them today. And he is an eviction attorney that's very close to our office local. So I will let him take it over. We're very excited to have him here. I'll let him do his introduction.
Thank you very much for the introduction. My name is Louette Cowell, and I am an attorney. I think I'll pass the 30-year mark as an attorney in another 6 months or so. Wow. 25 of those years is spent in eviction. So I've seen how the landscape has changed back then until now. In the old days, you got your 30-day, 60-day notice. You don't like the tenant, I'm sorry, here's your 30 days, get the heck out. That's done. Those days are gone. There may be a sliver of those cases left, in very unique circumstances. The tip of the iceberg that we're looking at now is the Tenant Protection Act that was passed in 2019. Various legislation were passed. According to the state of California, is to prevent further homelessness. They made the landlord a partner of their plan, to keep all the tenants in place. So TPA, Tenant Protection Act, is the tip of the iceberg. That covers statewide. Underneath that layer, you're going to have the county level. For us around here is the LA County unincorporated area, part of Rowland Heights, Hacienda Heights, and certain pockets here and there of various cities that belong to the LA County unincorporated area. Lastly is your city level, City of Pomona, City of Baldwin Park, City of Pasadena. They have their own regulation as well. And depends on the type of property you have, depends on the location of your property. You're going to fit into one of those legislation, and it's going to regulate what you can and cannot do. So I'm going to start with TPA because that is the overall landscape that all these legislation is based under. And we'll go from there. Your individual property may belong to the city of Pasadena, which will then be a different legislation that's going to apply. Some are a lot more stringent. Some are a little bit less stringent. Starting off with TPA, generally, it will apply to all rental property in the state of California. And that's just a general blanket. A couple of paths that you can opt out. And there is an automatic exemption, and there's also an opt-out provision. Depends on the property that you have. If your property is less than 15 years old, you're exempt. You're automatically exempt. You don't have to do anything. It is automatic. If the tenants move in there for less than a year, let's say the tenant's been there for 6 months, he's a troublemaker. TPA does not apply. Okay, less than 364 days. So the first thing that you want to look at any situation is to determine where is your property located. Check with the city, call with the city. Hey, do you guys have a local rent control? They may, you may not. You'll be surprised at how fast they pass these regulations and how they don't really tell anybody. It's almost incognito. The reason why that is important is that because once you have to initiate the eviction case, what's going to happen is that you fail to follow certain procedures that the city require, the county require, or even the state level requirement. If you fail that, defense lawyer is going to catch that, and you're done. Your case is no longer a good case. You have to go back and start over again. that will cost you time, money as well. Okay, so we always try to find out whether or not the property is exempt from TPA. And you also are aware that California made a big push in getting people to build ADU, junior ADU as well. Okay, so the distinction between an ADU and a junior ADU is that the junior is attached to the main house. The ADU is separate. Okay, so that's the distinction between an ADU and a junior. Now, under TPA, if the homeowner lives anywhere on that lot between the ADU, the junior ADU, or the main house, if the owner lives in any of that building there, that property is also automatically exempt from TPA.
Wow. No more than two. Read the pamphlet. You cannot have a 20 unit there that you live there. That doesn't work out.
That doesn't work, right? Single family unit,
Not
single
to-
family home, ADU, and a junior ADU. That is the only exception.
Not an apartment.
No. Let's talk about the duplex. Yeah, let's say you have two separate buildings. It's a duplex. Owner lives in one and the other one's being rented out. Is it exempt? It is not exempt. You're stuck with TPA. Okay, you're stuck. You're in the hole. Single family home, if it is owned by a mom and pop. Okay, there are a slight exemption for corporations and LLC. And Frank may touch on that in a little bit. But in general, if it's owned by a mom and pop, you must opt out. Otherwise, you are not exempt. Okay, does that make sense?
What do you mean by mom and pop?
Okay. You own it with your husband, you own that rental property, single family home. Right down there in West Covina. Okay, you own that. You rent it out to Mr. Tenant. Okay. You're utilizing a contract that was written, some years ago that has been updated. Well, guess what? If you did not opt out within that written document, you belong to TPA and you can only raise rent up to the cap that TPA will set, and you can only evict based upon good cause. Does that make sense? And here's where I see a lot of problem arising in my practice. The new rental agreement that you've seen, that's printed out under the apartment association, they do have the disclosure, the proper disclosure within that rental agreement. The problem is none of those boxes are checked. If you don't check the box, you're still included within TPA. Okay, you must check the box that says this property do not belong under TPA. So you must check that box. You'd be surprised at how many agents, they just don't check that box. And later on, when owner wants to evict, oh, you can't do it. Okay, can't do
I
it.
have a question too.
Please.
What about when you do want them to move out, about relocation fees?
Okay. The relocation fee works something like this. With regard to TPA, in order for you to get a tenant out, you must have good cause. And I'm assuming here that that unit is covered by TPA. You must have good cause. Okay. Owner, occupy, if that is your reason to evict, then yes, you have good cause. Okay, you must qualify that first run initially. If you don't, you can't even do anything. You're stuck with that tenant. Assuming that you have good cause, TPA will say this to you. You're either going to have to pay the tenant 1 month of the current rent or waive the last month of current rent. So that's the reload under TPA. it gets a lot worse.
Yeah.
LA City.
Hmm.
Don't even go there. You're looking at 20,000 plus easily.
Yeah,
Okay.
I sold a house and the agent had to pay the relocation fee because she wasn't specific on her form. Property to be vacant at close of escrow, well, one was vacant, but she didn't say both.
Right.
And she took us out of escrow, went back in court, she ended up paying, right, because we were gonna show specific requirements.
So relocation fee is pretty steep under LA County unincorporated area. And, you know, it ranges from 1 bedroom up to 4 bedroom, senior, tenant or minors or someone with handicap. You pay more. So that's just the way it is.
If you have, like what you were talking about, the old lease agreements, you know,
Mhm.
so can somebody then say, oh, okay, I'm under the old lease agreement and go back now, even years later, and notify the tenants that it's not under TPA?
That's a really good question.
I know somebody like that.
That the issue do come up. When the law was passed in 2019,
Right,
the law gives you a window, I
right.
believe up until like mid of 2021,
And if you missed
to
it,
give that notice to the tenant,
right,
to opt out.
July 1st,
July 1st.
before.
So back then, 2021, now
Right.
we can't go back in time at this point, we're stuck. Assuming that you didn't do it, you know, tenants now on a month to month. Mom and pop owner. House is more than 15 years old. You're stuck with TPA.
Okay,
You're stuck. That is probably where it's at. Now, it is an untested theory at this point. Can you just give a new notice to the tenant saying, hey, look, I'm giving you a 30-day notice, change of term, this property, we're opting out of TPA. Can you do that? That's an untested area of law. No case I've known have gone up into the appellate level to challenge that provision. I've seen it done. And as long as the tenant, you know, during the litigation, as long as the tenant doesn't fight back too hard, you might be able to get away with it. But at some point, that's gonna be called out in court, whether or not you can opt out at a later date. Yes, ma'am.
So let's say the previous tenant left voluntarily.
Okay.
And then so the house become vacant.
Right.
Are we allowed to rent the place with the fair market value, or are we limited to 10%?
Absolutely, you can do fair market value with a new tenant.
Thank you very much.
Hello,
Yes, sir.
follow-up question on that. Mom and dad was renting the place, the house, let's say, okay,
Okay.
and the 3 units. They move away, but now the owner, the landlord find out that the daughter or whoever, now they are living on the house.
Right.
And they pay the same rent or the agreement that they have with mom and dad 15, 20 years ago, which it was ridiculous.
I hear you.
On an issue like that, can the landlord come over and move them out because the contract is not with them, it was with mom and dad? And they.
I hear you. I hear you. Peter would know this in terms of contract law. A contract requires consideration and both parties has to think of the same thing to formulate or create a contract, you know?
Okay.
I'm gonna buy your car, a 1978 Camaro, my price is 5,000. We're talking about the same vehicle, the same amount. Here, the situation that you described, does the landlord have knowledge that the mom and pop has moved? Does the landlord have knowledge that the children are now living there? Those are the things that will come into play whether or not the landlord has that knowledge. If landlord has the knowledge and did not raise an issue, I think landlord may be stuck with the children now as a tenant. And he's stuck with all the tenant protection applied to the children as much as the parent did.
The reason my question, sir, is because I think a year or almost year and a half ago, I have an issue. Outside owner of the state. They didn't know that the previous tenants, they move away. Now the kids are living over there. They were paying like, I think it was 3-bedroom house. They were paying like $850 a month. Because, the
So,
contract, they didn't know about it, it's
Right.
out of the state.
right,
And they just received a check every month, and
right,
suddenly they came to visit family members, and they came and they come up and they found out about that.
right.
The issue is that they start to tell them that because they are under 18, have a daughter or something, it was a relocation fee that they have to pay up to $21,000.
Right,
The argument was, why do I have to pay the relocation fee if the contract is with Mr. or Mrs., which they are no longer living over here,
sure,
now they are different families living over here.
right. So the children in that case would have to argue that the landlord knew that they're living there. The landlord knew that the children were paying rent. And try to establish that the children have a landlord-tenant relation with the owner. They have to prove that.
Mhm.
Otherwise, the children are just subletting from the original
Yeah.
lessee. Does that make sense?
Mhm.
The mom and dad is the one who rented the place, so now mom and dad just sublet it to these kids. Mom and dad now takes off and the kids are just living there paying the same rent.
But even the landlord or the owner had to be acknowledged that they actually leasing the property to someone else.
In order to formulate a landlord-tenant relation, there has to be knowledge. There has to be knowledge. If owner doesn't know, he's living out of state, doesn't know.
Correct.
Suddenly one day he comes back and say, well, where are your parents? Oh, well, they moved away 5 years ago. Who are you? Oh, okay, you're the children? Well, I don't have a rental agreement with you. I don't have any business relation with you. They're gonna say, well, we've been paying the rent. And factually, that is probably true. That's gonna go to court at some point to litigate whether or not a landlord-tenant relationship exists. If it does exist, you're stuck with, relocation fee, rent cap. But if you, yes,
Most of the lease agreement they have, if you want to sublease to anybody, that you will have to have the consent of the landlord. But in this case, you don't have the consent of the landlord, so in what time frame would you think that there will be a contract or not?
yeah, unfortunately, the law does not establish a particular time frame as to, for example, if the children's been living there for 6 months, up to a year, 2 years, we look more toward the factual basis of that situation. Does the landlord know? And if the landlord knew and did not do anything about it, and did not raise an objection, you're stuck with it. Like, for example, if the parent's leaving, parent writes a note, sends it to the landlord, hey, I'm gonna be moving to Wyoming. My children's gonna live here. They're gonna be paying the same rent. Landlord got the letter, ignored it. I think you're stuck at that point. I think you're stuck. Yes, sir.
In this case, since the kids are living there, you have to write a new contract with the kids, or you don't have to write a contract with them?
It's up to you at that point. That's an optional point. If you want to write a new contract, to make sure that all the language is updated to the current regulation. And if the tenant is willing to sign it, then that would be the best way to go about it. However, my experience is that tenant will not sign that new rental agreement. They will say, well, look, I took it, under my mom and dad's old rental agreement, and we're gonna stay the same like that. So it will only work if the other side would agree to it. And I'll tell you an example, which is terrible. Lady is a doctor, right? She's smart. Her practice is up there in Pasadena. She has a rental property in Huntington Park. She liked to get into rental property just for fun. Okay, she wrote her own rental agreement. In that rental agreement that she wrote 6 years ago, it says this: if landlord wants to make a change on any terms to this rental agreement, landlord must get the consent of the tenant. Okay,
Wow.
Last 6 years ago until now, every year she raised the rent based upon the rent cap. She raised the rent. Tenant now refused to pay the rent, and tenant lawyers looking through that agreement and say, oh my God, she can't raise the rent on this contract because she's stuck. All that rent increase that she did is in violation of the rental agreement. She never got consent.
Here's a long food.
So now she's out of luck. So going back to the contract, it's good to have it.
Look, if the tenant pays the rent on time every year, after the increase the rent, would it be consent? It's like effectively the.
It is. And I would agree with you, but that is the point that the defense attorney brought up. And they brought up a motion for summary judgment, arguing that point that, look, here's the rental agreement. Yes, consent may have been implied because she paid it, but the rental agreement says that any changes must be in writing and must have to give consent. So we're kind of stuck, you know? People just get into a lot of mistake because they just don't keep up with the changes of the law. You would have to be really be careful about that. Let's see what else I want to talk about. Yes, sir.
Would it be legal to say, okay, you know what, I want to let you sleep, we need to, write a lease for a year or something like that, would that be okay for you, something like that? If they're willing to accept, to sign.
Yes.
Lease.
Yes,
And we can get them on.
absolutely. If they want to sign a new lease, ensure that the new lease must say that this lease supersedes all other lease. Does that make sense? It has to be the controlling lease. Okay. So as long as you have proper language in your new rental agreement, in your new lease, you should be protected. You know, because the code does say that the party can cancel the old lease as long as there's a new lease in its place. That's part of the CCP.
For your information, none of the lease have that statement there. So you sign a new lease, the old lease still wrangling it. Just double up. They have the same obligation. I mean, the landlord have the same obligation. The old lease exists. Plus a new lease. Unless you have that language there, say, taking over from the old one. None of the current lease have that language. None.
Can we add a paragraph that you mentioned it on the contract and initially they say you initiate you and that will be a.
I like that approach. I would do it as an addendum to the lease. You know, addendum number 1, dated on this day. This is the language, both parties signs it, attach it to the original document. You're good at that point. Now, once you're covered under TPA, be careful on your rent increase. Be really careful. As a matter of fact, be careful when you're doing a rent increase, check with the city to see if they have a rent increase cap on their own. Frank knows a lot about this and he will tell you, a lot of time landlord may have violated the rent increase back in 2022. And they did not violate in 2023. They did not violate in 2024. But when you go to court and the defense attorney look at the case in its totality, defense is going to say, well, look at you violated back here in 2022. So every increase thereafter is void. So now your 3-day notice for current rent is defective. You're done.
Yeah.
So be careful on your rent increase. Must be in writing, must give them a 30-day notice. Okay. Keep all your record in the file. Whatever document that you give notice to the tenant, keep it in the file. It's going to become relevant and pertinent in litigation. It may not, if you don't ever anticipate going to court, great. Nobody knows about it, nobody cares. But once you get to the court, everything is magnified. Okay. another thing that I wanted to cover, is pets. A lot of tenant landlord, they will sign a rental agreement where it says no pet allowed. And if they're a pet, you know, we may charge an additional amount for security deposit. Be kind of extra careful on that. And here's the reason. There are so many exceptions to that no pet rule that tenant will most likely be able to get around that. For example, emotional support animal, right? Tenant may not know this, but they will go on the internet and buy a certificate. I'm exempt, you know. Under the law, whether or not that certificate is reliable information, it's up to you to decide as the landlord. It may not be. How is it reliable? This person on the internet, we don't know who they are. They pay a fee and they get a certificate. That's not reliable information. But if you were to have like a letter from someone that's close to the tenant who will say that, yeah, this person, you know, may have a little issue. They require this animal to keep them in a comfort zone. That's reliable information. You cannot charge extra for that pet.
Hey, Luat, this is Jimmy. I have a question.
Sure.
If that's can't anybody write a letter saying, hey, I'm so-and-so's friend and he does need a support animal?
That is correct. As long as the information is reliable. That's the key word there under the law. So let's say a friend write that letter. Is that reliable information? Out of caution, I would have to say yes on that because the friend knew this person personally and can vouch for it.
Okay, perfect. Thank you.
All righty. But be careful though. When it comes to pet, it is a dicey situation. I'll tell you why. We just got a case. Frank would know about this too. 3 months ago, tenant kept a dog on the premise, and we assume that that was an emotional support animal. It turns out to be a pit bull.
Very emotional.
Turns out to be 6 pit bulls. Okay. Tenant orders something from Amazon. Amazon driver pulls up, goes in to make a delivery. You know, Amazon driver is an invitee. He's there to make a delivery. Somehow or another, the dog busts through the door, bit the Amazon driver, almost ripped her arms off, and now landlord's being sued. Okay. It gets kind of dicey when it comes to, you know, having a pet on the premise. I think landlord must be more aware of what's going on that premise. You know, like for example, okay, well, I'm going to approve you the first dog. That's fine, emotional support, but you know, now you have 6. Landlord might be on the hook for that one. I don't know. You know, it's still in litigation. We're still fighting on that one. Yes, ma'am.
Can I ask a question?
Yes, one moment.
Is there any limit of the number for emotional animal being permitted? Is there any limit of numbers?
Let me tell you the experience. I live here in Hamburg. I have my dog.
Okay,
And the people who give me the dog own 3 dogs.
okay,
Now, the county only allowed to register 3 dogs. However, Hamburg only allowed 2. So between city, county had conflict. So he was raising the dog in his own backyard, that not under the county supervision, I mean city. If a neighbor complain about it, they will have to get rid of that dog.
so let's say
Different.
maximum 3 emotional animals are allowed. How many certificates are we expect to see? 1 to cover 3, or each one have its own certificate?
Yeah, that's a good question. I think that's gonna be one of those situations where you're gonna have to make a judgment there. You know, normally if you have reliable information. Arguably, 1 or 2 animal at max 3 would probably be the maximum amount, but anything more than that, I think that's challengeable at that point. You know,
I think whoever gives out the certificate depends on who and if it's for 1 individual dog or if it is up to 3 maximum dogs. I think it depends on who does the certificate. Might be the city or the county.
Can you repeat?
I think the caller was trying to say that it depends on the source of the person who's making that reliable verification. You know, for example, let's say your church pastor is making that verification and the pastor said, well, he required this dog, you know, that's 1 dog versus, well, he required 3 dogs or something. I don't know if that can happen. We have not ran across a situation where they ask us for more than 1 animal under the emotional support animal provision. So we always try to keep the tenant on a tight leash there by saying, okay, we're only going to allow 1. You know, write it in a letter, confirm it, certify, mail it to the tenant. This way it's on record that, you know, you're making that limitation. You're drawing the line right there. So in the event that later on, tenant try to come through the back door and have 3 more animal back there, that's a vicious animal, landlord may be protected in that circumstance. Yes, sir?
Can
Guys renting a house and on the contract it says no pets. And the tenant has I think 2 or 3 pets.
Sure.
And one of the dogs bit somebody supposedly. But is the owner responsible for that or the tenant?
Could be responsible. Let's say owner didn't do anything, right? Let's say the contract says no pet and owner sees the pet there. Owner didn't do anything, didn't ask for any emotional support verification, nothing. I think in that circumstances where owner may have knowledge and didn't act on it, owner may be exposed.
Yeah, well, the pets are not supposed to be for emotional support. It's just like, you know, just to guard that house.
Right.
You know?
Right, but owner has to approach the tenant and say, hey, listen, I was over here in this neighborhood and I saw you know, there's a few animal in the yard. Are those yours? If those are yours, the contract says no pet. Could you tell me, could you give me an explanation or something like that? And at that point, leave it to the tenant to come up with the emotional support excuse. If the tenant can verify it, give you that reliable information, you're stuck.
Yeah, so they're trying to sue the owner.
Right.
can I ask a question?
Sure.
If the rental agreement authority established and then there is no pet as agreed between 2 parties, and then later on the tenant bring a pet letter of, you know, support animal and they want to bring animal, what is the rights of the landlord?
Pretty much landlord is stuck with that animal if the information is reliable, meaning that the verification for the emotional support animal, as long as it's reliable, landlord is stuck. Yes, ma'am.
Does that apply for rental, like a house, or like what if people rent out ATU rooms or whatever like that?
I believe it's equally applied to ADU and single family and apartment. They're all equally applicable.
Okay, thank you.
Frank, I know I missed a lot.
Now the pet issue, let me finish
Okay,
that.
wait, sorry. Let me get.
Oh, yeah, go
Yes,
first.
ma'am.
Thank you. So for the renter's insurance liability, and we name the dog covered with the dog, or then would that relieve the landlord the responsibility if that dog make some
I don't believe it relieves the landlord from liability. However, the insurance policy may alleviate some of the exposure of financial pain to the landlord at some point.
Sure. And then, so, rather, instead of a pet, we have the renter's insurance cover with the emotional support animal. Does the renter insurance cover that emotional support?
I don't know if your particular policy have that extension. I do know that in some commercial landlord liability policy, they specifically exclude animal. So you got to be real careful with the policy that you're buying. Make sure that you understand what is covered and what is not covered.
And I have a first-hand information. The rental insurance did cover the animal. Now, AAA, my daughter rented property in Fresno, and right there, they say you have to buy the, if you have a pet, AAA say, well, instead of $100 per year, gonna be $200. Now, I verified with some other source, they say farmer also sell the pet. Now, the farmer insurance need you to register, vaccination and all that stuff. So you buy that insurance, at least it's there, but nobody really do anything. Most people that I talk to, not until this year, none of the insurance, rental insurance cover that part because everybody want to pay the minimum. You have 100,000 for everything, right? It's not covered. They're right over there, the small print. So you say, I want to buy a animal that I own. They get coverage. You say, okay, then you pay it up instead of 100 or 120.
We can request that a rental insurance which covers the pets.
I'll tell you this, you can have that request in the rental agreement.
Right.
You know, tenant must procure some sort of a tenant renter insurance.
What?
Do they comply? That's the second key there.
Oh,
Assuming that they comply, everything's great. Assuming that's the case.
I saw renter's insurance, which is specify the dog is included.
Mhm.
I do see that.
Sure. In my experience, most tenants will not want to pay extra money when they're already paying rent. Therefore, they may show you a proof of policy, but they will either not renew it or cancel it thereafter. So what happened? This will lead us into our next part of the discussion, material breach.
Oh,
Tenant doesn't buy rental insurance. They're gonna say, well, screw you, I'm not gonna pay an extra $25 a month. I'm living paycheck to paycheck. They don't do it. What are you gonna do? You're a landlord and you found out that they don't have rental insurance. Can you kick them out at that point? Is that a breach? Well, for sure, that's a breach of the rental agreement. But the law will tell you this. Sorry, it's not a material breach. You can't evict. So when it comes to breaking terms of the rental agreement, it must be a material breach.
every time when the tenant unilaterally cancel the renter's insurance, would the landlord be notified?
I don't believe so, and I'll tell you why. The rationale is that the contract is between the insurance company and the tenant. You're just a third party.
Oh,
So there's no privity there between you and the tenant and the
then
insurance
what does
company.
that mean? Add the landlord as additional insurer. What does that mean?
Sure. All that means is that just in the event that something happened, then the landlord can also say, hey, you got to include my name on that check when you make that payment. I'm protected.
So even they add the landlord as an additional insurer, then landlord still won't be notified when the tenant.
I don't believe so because you're not signing that policy
Oh,
and you're not paying that policy. So you're not contractually bound in any way. You're just named as the additional insured. Yes, sir.
Yeah, like on the example I gave you, like, these families where if they have a contract that says no pets, and they have pets, will it be hard to get them off? Because, you know,
Tough cases because once that get in front of the jury, you're gonna have people who love animal. And that's the honest truth. That's the honest truth.
So what is the option for landlord if the tenant breach a contract, like bringing an animal all of a sudden in the middle of their tenancy? What do you suggest the option the landlord can can do so that they will not be taken advantage of like that?
It's a good question, what landlord can do so that they won't be taken advantage of. You can try to give the tenant a letter or a notice to cure. You know, provision 7.2 of the rental agreement says no pet. You have a pet on the premise. Please address this, this issue within the next 2 weeks or what have you. So that's the first thing that you would do. And assuming that tenant does not do so, then you're going to give a tenant a notice to quit. You know, I've given you an opportunity to cure the defects and you haven't done so. Here's your notice to quit. Then you're going to file that lawsuit in court. The best outcome at that point is a settlement with the tenant where they're going to move out. Because if you can't settle that case and it gets to the trial level where you go in front of the jury, I think you're going to lose. It just doesn't look good for a landlord to try to evict tenant with a pet.
Let me give you a solution. Let me give you a solution. If you rent a property to the tenant, management company do nowadays, they pay that what they call tenant the
Renters?
Rental insurance?
Okay, they including in there. Instead of 2,000, let's say 2,100, I'll rent it to you, but I'll pay everything. Remember, this is not material breach. So now my daughter moving in, they say, well, you got to get your insurance before I give you the key on that day. So she have to go AAA, pay it and get an insurance and give it to the landlord before the landlord turn the key to her, even though she signed the contract in advance. So that many management different style. I don't know what next year if she loses her insurance, if the landlord gonna go after her for second years. I don't know, but I have seen a lot of big rental property start including rental insurance there. So that's only one solution, and it doesn't solve your problem was already happened if it's tenant in there. It doesn't solve the problem. Moving forward.
So can the landlord buy renter's insurance on behalf of their tenant? They can't do that then? Is that what you're
Yes.
Included
saying?
in the, yeah.
So they're just buying it on behalf of the tenant and they buy the tenant. Okay, gotcha.
They pay for it,
Yeah.
$200.
Yeah, okay.
Frank, how many inspections the landlord are allowed to do? I advise my clients to do.
Minimum once a year, smoke detector, fire extinguisher, all that stuff. I own 4 units here in Maury Park. The city give me, fire department give me a notice, say, Frank, you got to inspect it. You got their certified fire extinguisher, and I have to do both. The only thing they concern is fire extinguisher. The fire department go there and check it out. However, they're not gonna go in each individual room to check it. They say, you self-certified.
Okay.
That's that.
If I could just add more to that, and this is from a legal attorney viewpoint. Landlord cannot enter the unit to inspect for no reason, right? Because the tenant is entitled to their covenant of quiet enjoyment. You have to find an excuse to go into the unit to inspect. And Frank mentioned that. Smoke detector, carbon monoxide detector. By law, health and safety code, every year, landlord is allowed to enter to inspect those units. As a matter of fact, I think the law says landlord shall, which is mandatory. So you give your tenant a 24-hour notice to enter based upon that health and safety code to inspect and or repair those units. Once you're inside, then you got to keep your eyes open to look at the unit around to make sure everything is good. Really, I mean.
What about?
What if you do in the contract, you already specified there, when you sign the agreement,
right?
I will do 2 or 3 inspections a year. I'm telling you because one of my clients, they do that.
I think that's borderline harassment.
Yeah.
And a lot of the
Yeah.
city, a lot of the rent control regulations, especially down in LA nowadays, they have an anti-harassment regulation built inside the rent control regulation. So if you do that and somebody finds out, I think landlord may in fact be exposed to some liability.
It's $1,000 though.
So the owner cannot go and inspect their property or anything?
Cannot, not without reason, okay? For example, if there's a water leak, tenant calls you up and tell, hey, there's a water leak here, it's pretty bad. You have the right to enter. That's an emergency. Okay. Number 2 is the tenant invites you in. Hey, listen, there's a small leak here. Could you come down and just, fix it? That's an invite. You can come down. Okay. But other than that, you cannot just give a 24-hour notice just to go in there and inspect. What are you inspecting? What are you repairing? You cannot leave it, open-ended like that. That's borderline harassment, and that's what we want to avoid. You want to avoid exposing yourself to any liability whatsoever. So as a pretense, use the code from use the law from the health and safety code, which said that you must go in there to inspect every 12 months. Does that make sense?
How about if the purpose is for the appraisal when you're selling the house?
Good point.
Yeah.
Good point. So let's say you tell the tenant, hey, listen, I want my appraiser to come down there and take a look at it. And tenant says, yes, no problem. Tenant says, no. What are you going to do then? 24-hour notice to cure. Hopefully they would cure at that point. If they don't cure, notice to quit. And in your rental agreement, you certainly have all the proper language in there already that landlord has the right to show the property and what have you. I believe landlord is in the right in that circumstances where if tenant doesn't allow access.
Question, let's say if you give a tenant a notice, 24-hour notice to enter into for the reason, and the tenant doesn't grant the appointment, does that consider as a breach of the contract?
It is a breach, and you're allowed to enter based upon whatever valid reason you have, If the tenant doesn't allow the owner to have access, then you hit them with a 3-day notice to cure.
Oh.
They have the right to cure that defect, by allowing access. If the tenant failed to do so, then you can follow that up with a notice to quit.
Wow.
That would be it, is a notice to evict, we call it a notice to quit.
Does that apply to insurance companies coming in? Because that happened to my daughter after college. And it was weird because she was the only apartment they selected, but hers is the cleanest in the whole complex. So like an insurance inspector,
Right.
only in her unit.
Right. That's an iffy situation, because if the tenant says, no, I don't want you to come in to my unit for whatever reason. At that point, landlord must give a 24-hour notice
Which
to enter.
yeah.
And if they did, then they're allowed to enter. Let's say the tenant say, no, I don't want you to come in, even with that 24-hour notice. What do you do then?
Mhm.
Notice to cure and follow it up.
So
with a notice to
insurance
quit.
inspectors are
I
valid.
think that's reasonable because that's part of a business transaction, the insurance company provide coverage to the building. I think that's a valid
reason. Yeah, that's what I thought. Okay.
Right.
I'm sorry, one more question.
Okay, you have a question?
I do.
Okay,
Is it a just cause, they're talking about those, if for pets, like say they don't have one at first, they get a service pet or whatever pet after, and you want to include it in their rent, put in agreements, like if you do get a pet, then your rent will be increased by an extra $100 a month. You can't do that?
No, you
has
can't.
to be
It's not a material breach. We're talking about it.
Yes.
Now, let me give you a practical point about violation. A lot of landlords give 24-hour notice, tenant refuse. Now, this temporary refusal is you say, I say. You go there, knock on the door, and say, I'm in the restaurant. Sorry, my daughter is not leaving yet. Come next time. Reschedule, reschedule, reschedule. Both sides have to have a consent.
So with regard to the dog, right? Let's say tenant brings in an animal, gives you a reliable information, that is an emotional support animal. In your contract, you said if you have a pet, I'm gonna jack up the rent by another $100. Guess what? You just violated TPA. See that? And on top of that, you just discriminated against this tenant. Now you're exposed to another liability angle. So it's pretty rough. True story, okay? True story. Tenant didn't pay rent for a couple of months. Landlord served a three-day notice to quit. Landlord then tried to negotiate with the tenant. Said, hey, listen, you're not a good fit here. You bother everybody around here. You don't have paper. Why don't you leave? You know, if you leave now, I'll waive whatever rent you owe. Yeah, guess what? Now we're dealing with a racial discrimination lawsuit. So don't negotiate, zip up, stick to the fact, okay? If they're behind on rent, 3-day notice, hey, you pay, great. You stay, you don't pay, I'm gonna serve you with some paper. There's no need to talk, to discuss, anything like that. Yes, ma'am? It could take upward to 8 months.
Yeah. Oh, wow.
Or as short as 2.5. Good question. I'll tell you why. Along with the fight against homelessness, state has fund a lot of law firm designed to defend the tenant, keep the tenant in place. So downtown LA, look, 85% of the cases there are now attorney represented for the tenant. And their only purpose is to keep tenant in place. You messed up by not registering your building. You messed up by increasing your rent by a hair over. You messed up by not posting your notice on the building. Those are ground to dismiss your case. So once you have an attorney on the other side, they demand jury trial. You're looking at 6 months at best, 8 months in a lot of circumstances, depending on how much volume the court is dealing with.
So, you don't try to negotiate, because in some circumstances, it's to your advantage to negotiate, so that you avoid litigation.
Absolutely.
Yeah, if you have good cause, then of course, you don't want to get into situation of discrimination or disability, you know.
Absolutely.
But, retaliation, but, you know, if you can give the tenant, hey, you know, I offer you some cash, you can go and look for some property, you know, cash for fee.
Right.
I think it's a legitimate.
It's very legitimate as long as you stick to that issue.
Yeah.
You know, like what my client did on this case was that he said, well, because you don't have paper, you know, you should leave. That makes no sense as to why he even said that. But again, negotiation will work if the tenant is not sophisticated, and they will take, you know, that option to move. Absolutely. Just don't say too much.
Yeah, right.
Okay,
What is the cost of eviction generally?
It depends, and I can tell you this right off the bat. If the defendant has a lawyer or the defendant demand jury trial, which I would say 90% of the time right now, tenant gets these forms from the courthouse and it automatically said on that form, tenants demand jury trial.
Wow.
Jury trial alone is gonna cost you upward of 10,000 to around 20,000. So that is really hard.
And the landlord pays that, or the tenant pays it too?
Tenant's not gonna pay it. I'll bring that up. One point here, okay? In a lot of our rental agreement, we always have an attorney's fee provision.
Right.
Hey, do yourself a favor and strike that out right now. Take it out. Who has the deeper pocket, the landlord or the tenant? If tenant wins, who's gonna pay them the attorney's fee. Exactly.
So what do you
Strike-
mean, this question?
Strike that out. You know, if you have attorney's fee provision in your rental agreement, month to month, 30-day notice of change, take that out. New rental agreement, cross out that provision completely. Don't give them the ammunition to go after you and win attorney's fee. Because believe me, when you get to that litigation portion, there's no guarantee you're gonna win. You're gonna go in there thinking, oh, look, he didn't pay rent, I'm gonna win for sure. It doesn't work like that. It's a rough water out there.
Favor. This is what I'm asking for. She went in and it's an implied contract. The owner did not give her anything. She lives in front of the owner. Now the owner's asking for it back. She wants her relocation fee. Right. But there's no contract. She wanted her to sign a consumer business. She says, I'm not signing anything. So she gave her, she goes, let me give you 13,000. She said, fine, half and half. Now she's reneging on them. So she says, I'm taking her to court.
Well, the agreement that you're talking about,
Nothing written, just
Right.
by actions.
well, nothing is nothing. We agree. Now, let's say we have something. Both sides sign something. Two things have to be concise. First of all, money have to change in hand. The contract was have a due date.
Yes.
Are you gonna give them money upfront? If they're on that day, July 4th, they move out, you give them 20 grand. July 4th, they say, no, sorry, I couldn't find a place. No money changing hands. They can call that contract void.
Oh.
So.
Because there's no money changing hands. It's really difficult.
She did give him a deposit when she moved in though.
That's a different story.
It sounds like there's already a landlord-tenant relationship going on, right? And depends on the jurisdiction that you're in, which rent
LA
control
County.
law, LA County, right, unincorporated,
Yeah.
you're on the hook for the reload. You're on the hook, whether or not there's rental agreement or not, you're on the hook at this point, okay? If you want to do a buyout, what you're telling me, right? LA County require the buyout to be in writing. LA County require a 45-day window for the tenant to cancel that buyout without penalty. So Frank here figure out a way where he's telling you to do this. Listen, fine, do the buyout. Don't give the money up front. Because if you give your money up front and tenant doesn't move, you're stuck. You lost your money that you pay, and now you're still dealing with this tenant trying to get this tenant out.
Now, RSTPO, which is county, they have their own buyout agreement. Not me. You can download it.
And it's very well regulated. So
And
you
the
buy
county
it,
want to have a
that
copy. Once you guys are, it's buyout, they call buyout agreement.
buyout agreement, you're buying out his tenants.
They call RSTPO buyout. It's right there. The county, after you sign, everybody sign, you have to submit to the county. County have their own mediator in between.
Okay.
When you change,
Let me get to this ladies first.
No. Let's say the tenant asks for jewelry. Let's say. And the jury can say the tenant has the right to stay.
It's not that
It-
simplified. May I say that? Because once you're in litigation, there are so many different dynamics that are going on between plaintiff's attorney, defense attorney. What are the legal theory? What are the defense? And I'll tell you this, like any instances of discrimination, that's the defense. Spousal abuse, that's the defense. There are so many defense that can be set up. So it's hard to say.
So before the jury make the final decision, does that mean the tenant doesn't have to pay the rent?
They don't pay anything until the ruling comes down. And assuming that you win, congratulations, you won $10,000 of back rent. There's no way to collect. You're gonna have to find his money. You're gonna have to find his Lamborghini to attach it, which that's not gonna happen. Versus the other way, you have property, they're gonna latch right onto your property. You're stuck.
Right. Right.
Yes, sir.
Yeah, questions. The first one, So it's really hard to evict tenants from here, right? Or
It is
that-
difficult. It is more difficult than before.
Okay. Number two, if they agree to move out, how much, what are the fees?
Depends on the jurisdiction you're under, LA County, city, LA County unincorporated area, or TPA. You know, or there may be local jurisdiction. Pasadena have their own law. Pomona has their own law. Baldwin Park has their own law. Bell Garden has their own law. Each city would have the recommended relocation fee. For example, Bell Garden, I believe, is 3 months of rent as reload. So it just depends on where you are.
Oh,
Is there more a common thing where you see evictions being successful? Like, is there a common theme that there's successful evictions without all this trauma? Is it just mainly for non-rent payment?
Most of the things that I see is that the tenants are sophisticated now and they will game the system.
Okay,
Meaning that they will request a jury trial because they know that in order to get to jury trial, it's gonna take 3 months, maybe
Okay.
4. Now they're living up to 6 months without paying rent. What do they care? It's
okay,
on your dime. The more they drag it out, the better.
Okay.
The only way that you can protect yourself is to ensure that you're in full compliant and that your case is not gonna get kicked by the attorney on the other side by pointing out that you failed to do certain things, you failed to register, you failed to post notice, you failed to mail a copy of the notice quit to the city or to the county. If you didn't do any of your pre-trial or pre-litigation due diligence, your case is gonna get kicked and you're gonna have to restart.
Are there landlord associations to help guide our clients who want to be?
This is it, right here.
Let me answer that question. Among our case, I have 35 more or less from January to now. Slowly, we process my office, get going, have certain sticky point. Mr. Cal sit down with the client, go through point by point, find out the weakest link that we can go after the tenants. But let me tell you, I receive about 20 calls a day. 18 of them does not exist. It's simple to tell the landlord that you have no case. What your cost of action to get your tenant out? Or they yelling at me, for example. You can yelling all day long, you have no case. Try somebody else. So I receive 20 case, 20 call, maybe 1 case, maybe. Now, 2 reasons. First of all, your case so weak that I have no case. Secondly, it costs too much that the landlord doesn't want to pay. For example, we schedule a certain people to meet Mr. Cal for her intention to move into the property. She's sticking on 175 consultation features, asking for how many hours, how many minutes. We gotta sit down and you gotta pay for your consult. You might not have a case, but she said, I'll do all the work, leg work. I say, okay, then you buy your own. If you need help, you gotta sit down and go over that.
In other words, there's no government support for landlord. You're on your own, basically.
That's right.
They are not helping you.
What is considered as a material breach?
Again, the word material is a term of art. It depends on each different circumstance. And I'll give you a clear example. We have to evict this tenant who lives in a condominium in Montebello. She put up an umbrella in her backyard. That's harmless, right? What's the umbrella do? It's shade. It's nothing.
Right.
Unfortunately, the HOA has a clear rule. Tenant cannot put up that umbrella, which is arbitrary, right? I mean, what's wrong with the umbrella? Nothing. Well, you dig deeper. Apparently, the fire department of Montebello is telling all the condominium developer that this is a fire department code. We don't want tenant to put up the umbrella in those condominium. So because of that, it became a material breach because we told a tenant over and over again, listen, please take down your umbrella. She was fined. We were fined by the HOA at least 4 times. now that became a material breach, so it's a sliding scale, so to speak. Yes, sir?
Does it make a difference in the property it's in the REAP program? Does it?
LA and RSTPO, City of Los Angeles County, only so far. Other place I haven't seen anything. Is in the code.
Only the city of Los Angeles?
City of Los Angeles and the county,
Not only one has a REAP
Yeah,
program?
unincorporated area.
uncorporated, they don't have. County just have it. They passed a law, the house, they call the rent habitability code that they allow the health department to check the property. And if you fail, and then you have failed, they can take away the rent from you.
REAP, that's the REAP
RIP
program.
program. County. And city have been that way for years, since 78.
Gentlemen. A couple years ago, I have an issue that we closed an escrow, we inherit the tenant. The owner left money in escrow for location and stuff like that. We went to the city in Los Angeles and talked to the rental department. They told us, in order for you to get a 60-day notice, you have to get the relocation fee check upfront. It's almost 20,000. And we argued with them, this sounds stupid. We're gonna give a $20,000 to the tenants. They've been living there for 20 years.
Right.
Then they decided not to move and come as squatters or whatever they want to do. But we did, if you don't get the $20,000 up front, you cannot deliver the 60-day notice. If that is true.
Yes,
Wow.
your money did not change in hand, that notice worth nothing. Remember,
For LA City, right, you need good cause.
15 days.
What are your good cause to evict?
Well, if we close the escrow, the owner is gonna live over there.
Okay, so it's gonna be owner occupied,
Yes,
all right? So you're gonna do an owner occupied, right?
yes, sir.
So in order for you to legalize that process, you have to apply with the city first
No.
and fill out all the paperwork. City has to approve it. Once city approve it, and they'll tell you how much as well. Then you open escrow, you put your money in escrow, and then you tell the tenant, hey, listen, the city has already approved it. The money's here. Come pick it up and you gotta move out.
Now, just for the note, escrow company no longer do that, all right?
I mean, they don't hold them.
No. First of all, escrow company, how much an escrow can charge for that 20 grand?
Right.
How much?
I don't know, you calculate for $500,000, how much is charged percentage? So they didn't make enough the money. And next problem, if a tenant refuse to sign out, take the money, or they have a dispute, everybody gets sued. So escrow companies say, we don't no longer will offer this.
Oh, okay.
Wow.
And even if city approved the owner move in and tenant doesn't, and you have to sue, you're still gonna litigate in downtown for 8 months. That's the fact of life.
Plus 20 grand.
20 grand, bro.
We agree,
Lost.
if the tenant receive the money and refuse to move.
Sure, I mean, again, you're gonna be in litigation for 8 months down in LA. Still. Yes, ma'am.
Thank you so much for all the
Can you
information.
briefly discuss when there's no contract and you have a stranger move into a home, so squatters?
Right,
The police won't kick them out,
I hear you.
so if you could just briefly talk.
Happy to. All the time, you leave a property empty, even though you lock the door and, the place looks normal, place is empty, your property will always be scoped out by the homeless. That is a fact of life. They will break in, they will tell the police, I live here, I have a contract with the owner. Police gonna say, okay, that's fine, you guys deal with it, it's a civil matter. You have to come to serve a 3-day notice to quit because they are a trespasser. They broke into the middle of the night, they gain access illegally. So you serve them with it's a 5-day notice. 5-day notice to quit. And if they don't quit, then you can initiate your lawsuit.
6
And
months,
again,
right?
downtown LA, 6 months. West Covina, you might get away with 2.
And then you have to pay relocation.
No,
No.
trespasser is different. There's no landlord-tenant relation.
What about if you put a sign saying do not trespass?
You can put a sign, it's up to the police.
Yeah, for the
Right.
police.
Right, and it's up to the police to actually enforce that or not.
Yeah.
Most of the officer or most of the law enforcement agencies that we dealt with, they're always gonna tell you it's a civil matter.
I don't.
Take it
have
over to civil court. They just don't wanna get involved.
So that sign, that is nothing.
Who needs it?
It barely helps. The thing that we see that help is that once you have the lockout already, the paperwork for the lockout, and the tenant breaks back into that unit and claim he's in possession, then you have your lockout, and then you tell the police officer, look, we had a lockout on this house a month ago. The same people have broken into and they're living there. Here's the lockout paperwork. At that point, the police may go down there and say, hey, get the heck out. To enforce, the trespass. Yes, sir.
I'd like to know that you have a breakdown on all your services fee. How are they, applying to different situations?
Frank would be happy to email you that list. So, if you want to drop your name and email address to Frank, he'll be happy to send that out for you.
Yeah, I used it before a long time ago.
There you go. I'm gonna be able to say.
He charges something, every item different.
It's hard because we cannot just have one charge for a particular event because there are so many different dynamics that's going through in an eviction case. There is, believe me.
Let me give an example. The ISTPO require 3 steps. The first step, you got to have the notice, tenant's right notice. That's one thing, right? The second thing, when you have that notice, they have all the right they have. Then you serve a 3-day notice with that copy of the notice, tenant's right notice to your tenants. And then you produce the proof of service. That's page number 3. And then you have to fill out another form and send to the city for the record. They call it proof of service from the city. They have their own form. So because of that, I generally charge $575. Some other law firms charge $6, $7, $8. I don't know, but $575 I think is reasonable. There's a lot of steps to do. Do it right.
So our email address is on here. If you have any questions, follow up, we'll be happy to answer it. Email us right here.
Frank, in events like that, if you need to go to court, will you represent the landlord of the court or will you do it?
If it gets to the litigation level, then it's on my desk.
All right, gotcha. You went to jail.
No way.
Oh, yeah.
Okay, guys, thank you so much. You guys are having fun. Thank you.
Very important.
Thank you.
Thank you, Peter. Thank you.
Great, congratulations. Yeah, you need to contact one more time.
Okay, you got it.
You guys have business cards? Thank you.
Yes, I do.
Thank you.
Thank you.
Thank you, Frank. Thank you, yeah. Very good. Very cool. Yeah. Let me stop the recording.
That's what's going on, it's a nightmare to get people.
This is very difficult.
In 2000, I think 2002. I was the video in somebody's unit. And back then, couple with no kids, under 18, it was 2,500. Somebody with kids. Or anybody.
Want me to make the glasses? No, I think you guys asking me.
And the only way to fix people back there was, you had to remodel the building.
Or library, now it's a new contract.
We have to stop the share.
Right, yeah.
Okay.
Or, yes, or they wanna fix the rent.
Okay.
Peter.
A couple of your business cards
Peter. I got it. Thank you.
have people that have this.
So that's.
Thank you.
Peter, let me have one, guys.